Make sure everybody's in awkward silence when your name gets called. Please stand up.
Stand by my vote. I appreciate it.
All right, everyone, I am going to, oh, I'm sorry, Zach.
Yes, Judge. How's it going?
Oh, it's going great. So I don't know if you had a chance to review this. And then after you reviewed it, if you can give it back to me, if you have any objections, so we'll take it up.
Yes, will do.
All right, everyone, I'm going to call the docket. Today is Friday Eve. Let's keep it that way. Let's not try to turn this into a Monday because today could easily turn into a Monday after a holiday. So, Christopher Acosta, Jose Lozano, Anthony Woodard, thank you, Lee Galindo, Walter Serna Martinez, thank you. In custody, we have Fernando Serrato, Tyler Stephen Small. In custody, we have Graciano Villanueva, Aria Frosto, Ralph Arespi. Thank you. In custody, we have Luis Franco, Martha Elizabeth Garcia is supposed to be by Zoom, Dominique Nicholson, custody, Tusca Hamrick, Fabian Ramirez, custody, Adis Hernandez Rivas, custody, Marino Vasquez Oleg, custody, Juan Carlos Rios, thank you, Ray Espinoza, custody, Preston Cam Lee, thank you, Samuel Bach, thank you, Jerry Torres, thank you, Karen San Miguel, who's saying she's on the way? All right, she's late. All right, thank you. Why are you here on time, but she is not?
I took a bus just trying to find a ride.
See, I tell everybody, take the VIA.
Right.
Oh, I did too. Yeah. Martin Yes. And when I was starting out as a defense attorney, clients were on that bus. Yeah. Anybody who has a DWI should take VIA. Yeah. Martin Torres. Thank you. Frederico Ojeda. Thank you. Dario Herrera. Dario Leos Herrera. They never show up when I don't pronounce the H. Raymond Sanchez. Thank you. Michael Johnson, custody. Humberto Cáceres, custody. Valentin Saldana, custody. Jesus Lopez, Louis Thompson, Joe Angel Flores, custody. Joseph Smith IV. Joseph Smith IV. Lee Martinez, custody. Paulo Lara. Where is he? Jesse Lozoya. Jesse Demas. Marie Morales. Kenneth Golfo. Mark Hernandez. Domingo Martinez. Okay, Carlos De La O, that's TDC. He's here, okay. Angel Pacheco Martinez, custody. John Meyer, custody.
Your Honor, may I step across the hall and handle a matter over there and I'll come back?
Yes. All right, everyone. Is there anyone here? Your name was not called or you came in late?
We were here last week. This is Ms. Garcia, April Garcia.
Okay.
But they called us back for the 18th, Judge. So
All right, what's her case number?
the case number is
All right, who are these three people on the front row?
They're with the victim advocate.
Okay, all right. Oh, I didn't see you. Hank, what you were hiding behind Hank. All right, I need the file for April Garcia.
Let me go grab it.
And what's your name?
Francisco Garcia.
Do you have a case number or SID number?
See number 838-5130.
Do you know who your attorney is?
Michael De Leon.
All right, just have a seat. Well, have you had contact with him? All right, we'll make sure he gets here.
I have the SID number, Judge.
Yes.
It's 1189082.
All right, and your name?
Good morning, Your Honor. Renee Gantu, SID number 994734. Attorney Roy Valera Jr. We filed for a motion for continuance till after my probation classes on May 4th. So I don't know, he said show up just in case.
All right, because that motion hasn't been heard.
Okay, yes, ma'am.
All right, thank you.
Yes, ma'am.
All right, anyone else who came in late or your name was not called? All right, so everyone, we have a busy docket today. We have a lot of people who are in custody. Once you request your client, if they are in custody, do not leave the courtroom because the deputies for security reasons can only bring out so many inmates. If you leave, once you requested your client, you're being selfish. So let's not make this a selfish Thursday. And you're being selfish because if your colleague shows up and they want somebody brought out, it's not going to happen because there's a limited number of inmates that can be out at one time. Remember the rules. If you remember these rules, the court will flow smoothly and efficiently. First thing, do not approach the court unless you've conferred with the state and conferred with your client. If your client needs an interpreter, when will they need an interpreter? If they wish to speak to the court in a language other than English, request an interpreter. Once you requested that interpreter, do not leave because we have a limited number of interpreters and they like to come in and be able to go to help in other courts. Once you have conferred with your client, conferred with the state, if you're ready to approach the court, just approach the coordinator, ask that your file will be pulled. Once your file has been pulled, just have a seat. There's no need to stand in line and look at me like, hey, I'm here. I know you are here. I'm calling cases in the order of appearance. The only exception to that is if your client needs an interpreter. Do not, I repeat, do not approach the coordinator. Do not approach the clerk while we're on the record. You will know we're on the record because I will have called the style of the case. If we do these things, it will be truly a Thursday's Eve and everything will flow smoothly. And if your client is in custody, yes, they need to be brought out. Probation is right back there. She is here because you all need to confer with her. If you have a client who is on probation, confer with probation. PSI report. Probation has the PSI reports. So everyone, keep your voice at this same level when you come before me so it can be easy for the court reporter. So I already know I'm claiming it. It's going to be a great Thursday. So everyone, please confer. Joseph States, and you always follow the rules. I like that. The SID number for who? All right, good. All right,
This last one.
let me see. Mr. Simmons, do you have the case number? They're having a hard time pulling up April's. I love your Fiesta medals.
25028. And can you?
25028.
And B, can you do A and B?
Thank
Thank you.
Melissa. Melissa.
Yes, Judge. Oh, lovely. Yes, and that's gonna match. That's gonna go very nicely.
Deputy Laura, I just sent you an email.
Well. Judge, do you have anybody else?
Yes. Joel. And if you would tell Michael DeLeon if he's here to come over. Yes. Oh. Okay. Oh. On these two, that's not, the attorney is here, so just whenever the attorney is ready to approach. And on this one, we're waiting for Michael DeLeon. Yes, thanks.
Hey, Judge.
Hello. Yes.
So it's funny you give me this. This is, of course, with respect to the defendant was picked up, and I think they're essentially hoping for a PR bond and then to kind of be placed in university hospital care.
Mhm.
If he takes them today, Judge, another separate person will be coming in. They have a brain bleed. They are in BCJ, and we have an agreement with counsel, Sally Unkefer, like, hey, let's get this person on a PR bond in the care of University Hospital. So oddly enough, again, this other person, hopefully James Hunt Defense will come in. I emailed them first thing this morning. But hopefully they come in and we can get a B page to you with like a really formalized agreement. I think this seems like the same exact thing. So I do have no opposition to this, but I'd love to talk with them.
Okay, so you can call them over and talk with them because I have some I have some questions.
Yeah,
About that
absolutely.
one, yes.
Yes, about this one, Judge.
Yes.
And I'm sure for the other one you may as well, but that one has been, they've been like talking with the chief and
Okay.
Victoria on intake.
Okay.
And I guess to be, Teresa, is this, I know she's with Bear, but do you happen to know who the defense, there's no defense attorney.
No, if you can check so did you look in the system to see if he was appointed an attorney or no?
I believe he has not been appointed an attorney yet, but I can double check if you'd like.
All right, and then if he hasn't, let's see if we can get if Norman can send someone down from Mac.
Absolutely.
All right.
Thank you, Judge.
Sure, no problem.
Yeah. I agree.
Better for you. Hey, you can't pull the revenue out, you can't pull the revenue out of the head.
Thank you.
Okay, no.
Hi, Bernie. So, I'm just discovered.
Oh, you want to stay?
And Michael Bennett and I don't know what we mean.
Michael Bennett is gonna be coming.
Okay.
You can give that, it's up to you.
Because we need these.
Correct. And that's why,
I know, the system.
for whoever is at the jail, maybe ask an attorney, instead of looking for them in cases, find a single one.
Exactly.
Absolutely.
No worries. Okay. That's it.
Possible.
Yeah, absolutely.
Are they email?
Yes.
See you. Okay. I didn't receive
Martin Ford.
so what I'll do is I have Adriana
Okay, just.
file scout them,
Okay.
and then she'll send them over to have them sealed.
Well, she needs to review and sign.
Correct. But when she's done with
He's
it,
about 50 years.
Okay, and then I got a
I can never figure it out.
before you guys. start.
you know what I'm talking about, ma'am.
Okay,
So you want to, now?
I'll just, yeah, let me, may I just put a bug in your,
Yes, I mean, but not a real bug.
not a real.
Okay.
I said it was on the docket and we will be approaching shortly. That I just need to put review.
Okay.
And I'll go to talk to those.
All right, sure.
Thank you.
All right, I'll take care of that now.
If you have any questions.
From pay it forward, Judge.
Yes. All right, who's your client?
Martha Garcia, Judge.
All right, is this the one that says honor? Okay. Okay. And what's her name?
Martha Garcia, Judge.
Let me see.
And she should be on page 5.
Okay.
It's like the third from the top.
So what is, it's been transferred to mental health?
Yes, Judge. She's almost on her way to graduate. She was at Pay It Forward. She is discharging from Pay It Forward successfully on the 22nd. So
All right, and they're watching a video
Oh,
on a case. That's okay. That's what the noise is in the background.
oh, sorry. Can I continue?
No, yes, continue.
Okay, so her new prospective graduation time is August 10th, Your Honor. But she's on track and she's doing well. We just want to make sure she steps down into sober living and has just a little bit, a month or so more of treatment to make sure she's doing well on her.
All right, Miss Martha Elizabeth Garcia, if you can unmute, please. Oh, I'm sorry. That's not you. Just a second. We're not ready for your case yet. I'm going to put you back in the waiting room. All right. So where is she now?
At Pay It Forward, Judge.
All right. All right, Ms. Ferguson. On this case, her client is at Pay It Forward. I'm accepting that because you're an officer of the court.
Yes, Judge.
All right. And you verified that, correct?
Yes, and I can forward an email to Norma. We sent the Zoom link to the facility yesterday, Judge.
All right. And since she's with the mental health court, that file should be transferred there. We shouldn't need any more hearings here.
Okay, Judge.
So what we'll do, so it can stay on the docket, we'll set it in 30 days. But Norma, just make sure it's in mental health court, because if it's been transferred there, all the transfer paperwork should be completed for it to be there.
So do you want me to put phantom date in? Because I don't want to override.
No, if it's been transferred, then there's no need for her to show up here again, and this shouldn't be on our docket.
Okay.
So if you can make sure it's removed from our docket.
Yes, ma'am.
All right. Is there anything else?
No, Judge, that's the only case I have in here, maybe, excuse.
All right. Have a good one.
You too, thank you, Judge.
Okay, bye-bye. Hello. Oh, and just one moment, counsel. Someone has just zoomed in. I don't know if this is what paid for it or not. Could you start your video, please? All right, could you unmute, please? Hello, what's your name?
Samantha Flores.
Well, just one moment. We'll put you back in the waiting room. Sorry about that. All right, thank you.
Thank you, Judge.
Thank you.
There's always next time. Oh, we'll do. That absolutely. What's about this?
Hello, did you need something?
No, ma'am, I'm sorry. I'm just looking at what's.
Oh, no problem. Okay. Kenneth Golfo? Kenneth Golfo.
That is on that one. Yes, you're exactly right. Yeah. Once more.
All right, Deputy Laura, on him, could you check to see if he's in custody? Okay, all right, thank you.
Oh, I thought it was actually 6. No, but it sounds. It's still pulling up. Okay, yeah, no, so I think once defense case. No, the committee thing, no, I don't mind. We can put them on the committee. On. Yeah, like no opposition transfer out. Kennedy. We literally just. That's show us how. So. He's gonna be in a facility. I don't know where he is. Yeah. You're exactly right. Well, nice to meet you.
All right, Norma, here's this.
Yeah.
Can we lock it in the back?
You confirmed on that case.
You ready?
Yes.
Sure. Norma, is Ray Espinoza on the docket?
Yes, yes.
Could I see the file, please?
No, absolutely not. No, so we're.
Yes.
All right, no, yeah, they're not technically ready. I just needed to write something in that. And here's this, if you can make sure that defense counsel gets a copy, only defense. April Rose Garcia. All right, so what's happening with this case?
Judge, we think we have provided all the discovery.
Everyone, please whisper. Yes.
I would like to ask for a little more time to contact the complaining witness in this case.
All right, and defense, do you have all of the discovery?
We have them all, Judge, just on the computer. I'm thinking that we do have all of the videos, but as I was looking at them, some of them, for example, wouldn't play yesterday. But then I just tried some of them on my phone, some of them were working, so it's.
Okay.
I only hesitancy, Judge, is that I haven't been able to play them all on my computer or my phone, because like I tried to show them on the phone that it wasn't working, and then it did. So.
All right, Miss Ferguson, on April Rose Garcia, can I have a 30-day reset? That's going to be your final date for discovery and the date to contact complaining witness.
Yes, ma'am.
All right, we'll be back on May 20th. Once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, you're welcome. Are the parties ready? I'm Ray Anthony Espinosa. Hello, good morning. All right, and defense, make sure you get a copy of the motions I've signed on.
Thank you, Judge. I appreciate it.
Okay.
I'd have to look at it.
All right, so the last time we were here, there was a discovery for the hard drive
Correct.
and you all exchanged hard drives?
We did.
Okay, and then that's where we are. We're here now for more discovery. Do you think you have all of the discovery?
So the situation is, Judge, it appears that there has been a new allegation leveled against the defendant while he has been in jail.
Okay,
And Michael De Leon was somehow appointed to that case.
okay,
So we're just waiting on him so that we can do a little bit of a swap so that Mr. Bali and I can get the discovery on that new
Okay.
offense. I don't think we need to exchange hard drives for that. I think we just will need to be able to upload it from the e-discovery system.
all right. So this is what I'm going to do on this case. And y'all will need to confer off docket a little bit.
Okay.
I'm going to give you, because of the nature of the offense
Sure.
and because there's more than one charge,
Yes.
I'm going to give you all a 45-day reset for
Got it.
discovery.
Okay.
When we come back, all discovery needs to be prepared and you all need to be prepared to do an acknowledgement of discovery. Is that possible?
Yes, I believe that is possible.
All right. Ms. Ferguson, on Ray Espinosa, I'm going to need a 45-day reset.
Yes, ma'am. I can
That's perfectly fine.
All right. June 3rd. I am back to writing 2023 for some reason. So, and then counsel, if y'all would like, do you need a third attorney on this case? Because then Michael could stay on that case plus on this, if y'all would like.
It's fine with that. It won't make any, if that's what the court would like to do, that is perfectly acceptable. However you'd like to do it.
You want me to ask Michael when he comes in?
Yes. And then, I don't know, if there's extraneous stuff, maybe he can handle the extraneous
Yeah,
stuff.
and there are 3 misdemeanors. There's other stuff. So
All right.
that's fine.
All right. So if you can see when Mr. DeLeon will be here.
He said he'll be on his way, Judge. Could you ask me to contact him to come for the other client?
All right. Thank you.
I'm going to.
All right. Is there anything else on this case?
I don't think so, Judge.
All right. So they say Mr. DeLeon will be here shortly.
Thank you, Judge.
Okay, thanks.
I'm gonna go get those copies.
All right. Thank you.
First row.
Oh, gotcha. Yeah. Hey. I'm looking in their box, there's not a file, and I look at. It's indicted. Oh, he's here, I'm here. We're speaking to the state, maybe we can.
Yeah.
Well, I don't know if we're gonna take care of it.
You can approach and let her know when she can give you a reset.
Oh, sure.
Yeah. If not, I'll bring you back on Monday.
Let me speak with the state.
Yeah, thank you.
I'm sure. All right, I thought you were.
Ah, Michael DeLeon,
Sure.
could I see you in the back for a moment?
Thanks again.
Deputy Laura, I just need 2 minutes. Martin Torres. And where's Martin Torres? Come forward. And this is family violence. All right, what is happening on this case?
I was just appointed yesterday.
Okay, so,
Not much we can do with it today.
well, have you got discovery? Have you looked at discovery?
I looked a little bit at the file. I've talked to my client and the witnesses, talked to the prosecutor. I just, if there are any videos or anything, I would like time to be able to watch them and download them. I haven't even had a chance to do that yet.
All right, Ms. Ferguson, if we can have a 30-day reset on this, please. That will be your final discovery date, and state will need to be prepared to make an offer at next setting.
I can do the 21st, May 21st.
All right, you'll be back on May 21st. Once you sign the reset form, you're excused.
Thank you.
Thank you for dressing appropriately for court.
Thank you, ma'am. I'm sorry, this is the best was I had today.
Oh, no, it's great. All right, once you sign the reset form, you're excused. All right, it has Anthony Miller appointed. Is Anthony Miller not? Okay, all right, thank you. All right, thank you. Humberto Cazares. I did the pause for you. All right, this is family violence. Where are we on this case with discovery?
We have requested CPS records, but have yet to receive them, Judge. Once we do, so you'll be in a different ballpark.
All right, so what's the time frame on the CPS records?
I'm not sure, Judge. I'm gonna reach out to the intake side and see if they have an update specifically with respect to timeline. So it was done late February, either
Mhm.
February 28th or if this is a leap year, whatever the last day would be.
Mhm.
So we're just in like a month-ish period, month and a half-ish. So I apologize, I don't have an exact
No
time
problem.
frame, Judge, but I will follow up with the intake side today.
Do you have a legal case with CPS?
¿No tienes delito con CPS?
No.
All right,
You said,
ask him,
you said they interviewed him at the jail, Judge, and that's all they've done with him.
all right, does he have a CPS attorney?
¿Tienes un abogado con? No.
All right, so is your client a citizen?
No.
All right, Norma, he needs an immigration attorney. Are you retained?
No, Judge.
All right, so he needs an immigration attorney. And next time, council will need the interpreter here. And it sounds like if they interviewed him at the jail and it's this, you may want to reach out to the prosecutors in CPS court. They may have the records.
Yeah, Judge, I'm gonna write that down. Thank you, Judge.
Sure.
We can do Mac. Mac is the only.
Yes. All right, and then let's recall this in 30 days.
21st of May.
All right, we're going to come back on May 21st. Is there a chance that he's going to be released or is there an immigration hold?
Immigration hold, Judge.
Okay. All right, Norma, then he's done.
Thank you.
Thank you, Judge.
You're welcome.
I'll be excused, Judge.
Yes.
Thank you.
I can take that from.
Yes.
Juan Garcia.
May 21st. May 21st.
May 21st. Yeah.
Good boy.
Yes, sure.
So, that one gentleman here on the.
I'm sorry, what?
I have a gentleman here on the interior. I'm just trying to confer with Mr. Garrett and Daniel's in the hall, so I know that that's what else people would do. I'm trying to get drugs like this.
Okay,
And then hopefully we can announce who was in there.
all right, thank,
We're setting on it.
okay, sure.
Thank you.
You're welcome.
No.
Yeah. Thank you.
I will.
Yeah, no. Yeah. Garcia. That was A and the B. Judge, can you? Garcia.
The only file I have is Jose Lozano.
Dario Herrera. A. Dario.
She needs 4.
Yeah.
You okay and
Yes. Sure.
that one was the B, right? Yeah. Well, he needs to be with you.
You're welcome. Joel Garcia, Joel Francisco Garcia.
Coming, Your Honor. Apparently this morning, Your Honor, his wife, co-defendant, got 30-day reset with Attorney Simmons.
Yes,
Looking for the same day, pretty please.
yes. All right, so that is going to be May 20th. And thank you for dressing appropriately for court.
You're welcome.
All right, so that's going to be the final discovery date. All right, Ms. Ferguson, on Joel Francisco Garcia, if you can set this for May 20th, please. All right, thank you.
Thank you.
And once you sign the recess, I'll be excused. Samuel Bach.
Yes.
Hello. Hi.
Hi, good morning.
Thank you for dressing appropriately for court. All right, so we are here and today is plea deadline day.
And Your Honor, we have received the plea offer and we have rejected it.
Okay.
This is a complicated case. We will need to approach the court ex parte on some issues, as well as need time for investigative work, additional investigative work. There are medical records in this case that we need access to that we don't right now. We're working with the court, but
Has anybody subpoenaed the records?
we haven't subpoenaed them because we just got to the point of realizing we cannot work it out. And that requires going to the family of the complaining witness who's deceased. And before we went that route, we were trying to figure out if we could work it out.
All right, Ms. Ferguson, on Samuel Bach, set this for jury trial within 60 days. That's your trial date. Sure. Because this has been on the docket since January.
And with all due respect, it has not been the defense that has been asking for the resets. It has been the state so that they could confer with their complaining witnesses.
Well, I mean, I'm saying it's been January as it relates to discovery. So,
And at the last setting, and they let us know that there was medical records that actually were relevant that we don't have access to that are of the deceased. So that were relayed to them by the complaining witness's family. I just spoke with the complaining witness's family. They don't have those records at this point. So
and see, this is the court, and I'm not trying to be combative, but this is what I don't understand. I don't understand why people don't go forth and try to seek out all the discovery. It seems we're in the information age, but people don't want information. It's the nature of this case, I would think, and if I'm wrong, correct me, it's a manslaughter. I'm thinking automatically there has to be some medical records, and people would want those medical records. So it's going to be set for jury trial within 60 days, and you all subpoena whoever you need to subpoena, and whatever happens, happens. But discovery has been going on since January of 2024, and here we are in April, and no records have been subpoenaed. So, Ms. Ferguson.
June 11th.
All right, June 11th is going to be your jury trial date. Once you sign the reset form, you all are excused. All right, thank you.
I apologize. Can I get some clarification? Is that the announcement or is that the picking of the jury?
Let me see.
Tuesday, it's the beginning of the jury.
Yep, selecting of the jury.
Okay, is it possible to also then have a date the week beforehand to come in to handle any pretrial matters or?
Oh, you'll have to just schedule that with Ms. Ferguson.
Okay, all right, because we are going to need pretrial
Sure.
motions and stuff.
All
Okay,
right, thank you.
thank you.
You're welcome. You're welcome. All right. I can't even understand this writing. Who wrote this?
I did.
All right, and where's your client?
At the jail now. That's right, Judge. This is the similar kind of mental health sphere that is similar to the other paperwork.
All right, does anybody want to write this out so it's legible?
Yes, Judge, I can help out with that.
All right, thank you.
Should we start?
Here you go. Who's here on Walter Jean Cerner Martinez?
Me, Your Honor.
All right, and where's your client? Hello, thank you for dressing appropriately for the court
Of course, Your Honor.
and with a little fiesta thrown in. All right, what's happening with this case?
Judge, I just got hired on this case. This is the first setting on MTR. He did report to his officer Borrego 2 days ago. She instructed him that she would like him to do a retreat, very active in church. And so do a retreat on May 2nd. I would like to see if we could put a date beyond that to verify.
All right, state. On this case, he's saying that he was just retained, so he's asking for a short reset.
That we're not opposed, Judge.
All right. So, Ms. Ferguson, probation on Walter Jean Cerner Martinez, defense counsel is asking for a reset. He was just hired. So what we'll do is we'll set it for a contested in 30 days. And if it's not, it turns out it's not contested, then it won't be contested.
Thank you very much, Judge.
Oh, sure. Just one moment. Let me get a setting.
You say that's it, Judge?
Yes, it's going to be on Walter Jean Cerner Martinez. It shouldn't be that many.
May 9th.
All right, May 9th. All right, once you sign the reset form, you're excused.
Thank you
And
so much.
sir, you need to make sure you stay in contact with probation. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you so much, Judge.
You're welcome.
Judge.
Yes, is your file pulled?
It is. If you're gonna be a while before you call it, I have another sentence in another court.
Well, did you ask for an interpreter? Does your client need an interpreter? They haven't pulled your file then, because I don't have it.
It's on my judge. Yeah.
Ah. All right, let me take up this in immigration, and then I'll take you up next. Who's here on Marco Antonio Marino Vasquez?
He's present.
To the interpreter, that's the person.
Thank you, Judge. Good morning.
Good morning.
Oh, no, it was for Joseph States and, but that's fine.
Yes.
Okay.
Good morning, Judge.
Good morning. Where's your client?
He's in the box.
All right, if you have him come down.
Hey, this guy's doing a victim. Heard about his.
Yeah.
Let's come back in.
Thank you. Thank you.
Today's the plea offer day, Judge.
Mhm.
We received it. I conferred with my client.
All right, on this case, so an offer was tendered.
Yes, Judge.
All right, and has your client had a chance to speak with the immigration attorney?
We discussed this last time, Judge. The charge is murder, so it
Yes,
doesn't have
we
any
know.
bearing. It'll be automatic deportation if he's convicted of the charge and then released after his stint in prison and or probation.
All right, and you have all the discovery?
I have all the discovery. They just finally got the transcript of the translation of the interviews. Is that right?
Correct.
All
And
right.
So I'll get that. The last time we were here, Judge, my client brought up the issue that he wants another attorney. He's upset with me because I won't file a motion to withdraw. At this point, there's still not a conflict.
Okay, all right, so here's the thing, Mr. Moreno Vasquez, I want you to hear me and I want you to internalize what I'm saying, okay? If you want another attorney, you need to hire one. Do you understand?
Yes.
I don't know what the issue you may or may not have with your attorney. Sometimes the issue people have with an attorney is they're not getting the offer. They're not getting the offer that they want. Here's the thing. I've been a defense attorney. I've been a prosecutor. In this court, I require that the state tender an offer to the defense. You can either accept it or reject it, or you can tell your attorney, I'm accepting it, in which case we will do a plea bargain agreement. Everyone, please whisper.
Thank you, Judge.
If they make an offer and you want to accept it, then we'll do the plea paperwork. You will enter your plea. If they make an offer and you say, I'm not accepting it, then one or two things will happen. Either you go to your attorney and say, I'm not accepting this offer, but I will accept A, B, or C offer. That is what's called a counter offer. Your attorney will take what you will accept, if that's the case, to the state. And then at that point, the state can say, all right, we will accept the offer that you want, or as we call it, the counter offer, or the state will say, we're rejecting that offer. And the only offer we will make you is the offer we made you. Do you understand?
Can I say something? Yes.
If you want to say something about what the state offer is, no, because I'm not allowed to hear that. Plea negotiations are supposed to be confidential unless you're accepting an offer. Do you understand?
Yes.
If you want to talk about the facts of your case, the only way I will hear the facts of your case is if you are entering a plea bargain agreement or if there's a jury trial or a bench trial. Do you understand?
Yes, I just want to talk about my case, that's all.
No, the person you speak to your case about is your attorney.
Okay, si me lo puede cambiar, no? Yes, can you change attorneys or not?
All right, hear me clearly. Abogado, you need to hire one. I don't know why people think that when attorneys are appointed to them, and I mean no disrespect when I say this, it appears to me that sometimes beggars are becoming choosers. If you see somebody who needs food and you offer them a hamburger and they say, no, I want lobster. This is your attorney. There's absolutely nothing wrong with this attorney. If you want another attorney, you need to hire one. Do you understand?
Okay.
Sí, es que como ya tengo tiempo, sí, nomás, y nunca me ha dicho nada, pues nomás estoy.
Yes, it's been a long time and he has never said anything to me, so I'm just waiting.
Oh, well, here's the thing. You're here, he's here. He can say something to you today. But my question for you is, did you receive the offer? Yes or no?
No.
No.
All right, so he said, I know, but if you will indulge the court, he's going to tender the offer to you that the state has made. When he tenders the offer to you, I want you to internalize it, think about it, and then you will come back before the court and you will let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, I understood.
All right. Thank you. You're welcome. All right, on Jose Lozano, is this going to be a long hearing?
I don't have any witnesses either, Judge.
Oh.
I just have the complaining witnesses are on Zoom for a PSI.
All right, where's Mr. Lozano? All right, everyone, please have a seat. If you're not on this case, Court is calling 2021 CR 7016, State of Texas versus Jose Lozano. Can I have the parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Raymond Martinez for Mr. Lozano.
And are you Mr. Lozano? All right, we are here for sentencing. A jury found you guilty. Just one moment. And they found you guilty of the offense of theft, $300,000 or more as charged in the indictment. Have both parties had a chance to review the PSI report? State?
We have, Your Honor.
Defense?
Yes, Your Honor.
Any corrections or additions to the PSI report? State?
No, Your Honor.
Defense?
No, Your Honor.
All right. State, what are you requesting?
Your Honor, we're asking that you sentence the defendant to 15 years in the prison.
All right. And the reason?
Your Honor, the defendant was convicted of a first-degree felony offense in this case. Reading the TAP evaluation, he's shown no remorse for his actions. He doesn't say this was the result of being under the influence of drugs or alcohol. His story about how he says this happens is just not credible. Doesn't jive with the evidence that we saw at trial. He says that someone offered to sell him $300 worth of items, over $300 worth of items for $600 to $800. He says his friend brought the trailer to him. The evidence that was elicited at trial indicated that a window of the truck was broken. So it's pretty clear to me that he knew these items were, the very least he knew these items were stolen. But Your Honor, what he's convicted of is theft. And I guess the other part of this, the TAP evaluation, they talked about his home life a little bit. He says he has regular contact with all his kids, but evidence elicited at the trial was he's not paying any kind of child support to Edith Serrano. That was one of the victims, you may recall, Your Honor. Or I'm sorry, one of the witnesses at the trial, Your Honor. I know you were presided over this case, Judge, so you remember the testimony, but Terry Kirkbride and his wife are moving from California to Florida, and they lost almost everything as a result of this theft, Your Honor. But what Terry said on the stand is what really stuck with me. And what he said is the hardest part about this is that he lost things in this theft as a result of this theft, as a result of the actions of the defendant that cannot be replaced. So the hardest part of that for him were the photos that are just gone forever. The things that he inherited, the things that his wife inherited, they're gone forever. Items from his military career that are gone forever, damaged or lost. And so that's what I want to emphasize to the court. And the other part of the thing I want to emphasize to the court, Your Honor, is we're asking for this sentence to protect the community from these types of thefts. This property crime, I think, especially folks who are involved in the criminal justice system, we can get sort of jaded and think, well, nobody died, right? But these crimes are very serious. And the victims in this case lost nearly everything that they own. And so, Your Honor, we're asking that you protect the community from these types of crimes and sentence the defendant to 15 years in prison.
All right, defense.
Judge, if the court recalls from the facts of the case, I think Mr. Lozano's explanation is perfectly plausible. There was absolutely no evidence presented by the state in the trial of the case that he was present when that truck was stolen, whether he ever drove that truck, ever had contact with that truck, it was ever on his property. His suggestion that the guy brought the trailer to him to see if he wanted to buy it is consistent with somebody who did steal that property, trying to go and pawn it off on people. Him paying $600 or $800 for what was the contents is because all the valuables were already gone. All that was left was a bunch of stuff that after whoever stole it, poured through it. He admitted, yes, my print is on the trailer because he showed it to me and he wanted more money than I could afford. And so I didn't buy it. He offered me the other things that were there. The complainant specifically testified in his testimony, the things that were at Mr. Lozano's property that they recovered were of little or no value, right? If you look at the PSI report, when they go to the restitution, it says approximately $300,000. How can you approximate that when he's already been found guilty by a jury? Well, this court knows why. It's because her math was a mess. The complainant testified in the trial of the case that he agreed in writing a contractual agreement with the insurance company to settle for $240,000. The theft statute is very, very clear. It's the value of the property at the time it's stolen, not what you paid for it years before.
So when you read their exhibits, and the jury obviously never did, they put no attention to the real evidence in the case. They felt bad for the complainants. I feel bad. We all do. They suffered a great loss, but they didn't prove he was the one who did it. They proved that he was a party to being in possession of some of the stolen property. That's why we had a jury charge all the way down to a state jail. That was the appropriate charge. This case is ripe and full of appeal issues, especially on the issue of the value and sufficiency of evidence. This case does not merit a day in prison. I get it. It's a big loss. But if you look at the exhibits, and I was going to bring it to you, but it's in the court's file or court board's file. USA went through an exhaustive list, and he says I spent months and I kept updating it, telling them all the things that I lost. They put the retail value, they depreciated it down to the actual cash value at the time of the loss, right? He signs an agreement, accepts the check saying $240,000. And that included the truck.
All right, so just so parties know, I'm not going behind the jury's verdict.
I'm not asking you to,
Yeah,
I'm just saying the punishment should fit the crime. The jury did what they did, and that's for another court to look at, whether there was sufficient evidence for their verdict. But my suggestion is, if they've proven that my guy drove off with the truck and the trailer and he had gotten rid of everything, I can see that this is a different case. There's absolutely no evidence that was presented to suggest that. And his explanation fits squarely within the facts that were presented in this case. So I get it that there's restitution. My client is going to have a lifetime consequence because of his resident status of potentially being excluded from this country. So he is going to get punished severely by this court and probably another one. So all that being said, Judge, we'd ask the court to sentence him to a term of probation. We'll pay restitution to their number as best he can, as long as he can. But that's the appropriate sentence. If we're going to start locking up every person who goes to a flea market and those people that come into property illegally and they get it in their possession, we're going to start sending them all to prison. We don't have a big enough jail for that, Judge.
All right. Is there anything you wish to say?
Yes.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, and make sure you keep your voice up so the court reporter can hear. Who's the name of the friend that gave you these items?
Who's the name? I don't know his name. They called him.
Well, I mean, you say he's your friend.
Well, yeah, but
And you say you received a phone call from a friend.
yes, should have wrote it down.
All right, so here's my other question. The items, because there were some items that were related to his military career. When you saw the name of a person's name on military paperwork, what did you think?
At the point already, I had the stuff in my house. I didn't know what to do with it anymore. It was there. I bought it. It was in boxes when I bought it. By the time I got to open it, I saw the stuff.
So how much money did you pay for this stuff?
About 800, whatever was in the trailer, I got it off. About $800 and $900.
Did you look through everything before you paid 800 or 900?
Boxes.
So you just take a boxes sight unseen, sort of like Storage Wars?
Oh, yeah.
All right. And so you don't know your friend's name who phoned you. According to you, it says that you were home asleep on this date and you received a phone call from a friend.
They call him Chaparro, but I off the top of my head, I can't remember his name right now. I'm sorry.
Oh, no problem. I just wanted that cleared up. All right, this is what the court is going to do. Court is going to sentence you to 6 years in the prison, give you credit for any time served. With regards to the amount, the court does not deal in approximations. So for the court, there is no restitution because there is nothing here to suggest a restitution amount. It just says approximately $300,000. There's nothing I can do with that. And this trial was on March 21st. I'm sorry, just one moment. Yes, March 2024. So by that time, there should have been some amount to the court. So I'll give you credit for any time served. Is there anything else with regards to sentencing, state?
Judge, is the defendant's birthday, May 1st, 1998? Is that right?
You can ask him.
Okay. Is that your birthday, sir? May 1st, 1998?
Yeah.
And Judge, would you incorporate the evidence at trial as to the value? Would that be something you'd be willing to do?
No, because again, the amount that's listed in the PSI report is approximately $300,000. And then defense counsel is correct with the amount that the complainant settled for. And I know how insurance companies do sometimes.
Probably
the amount, the amount the insurance company settled for was $240,000. So this is where we are.
If I could, just one last thing on the record. I just wanted the court to be aware, the record to be clear, that approximation comes from the complainant. The PSI officer called the complainant to ask him that number, and that was his response.
Yes.
Even after his testimony that was presented to the court.
I'm not ordering restitution unless there is some sort of deductible, which the court has not received any information on a deductible amount. So the court will sentence you to 6 years in the prison and give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor, we just have victim impact fees.
I do, Judge.
Yes.
We will be filing notice of appeal and a request for an appeal bond. Do you want to take that up today or?
Oh, you have to file the motion and the court will take that up. So if you could have him fill out the trial court certification.
Well, they're going to be filed today. That's why I'm asking if he could be kept in court today so we could address it or.
It's going to have to be another date. All right. If you could have him do the trial court certification, so I could do that now, please.
Do my magic backwards.
You're saying.
Yes.
She wants it.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Yes. All right, you have a right to an appeal as this was a jury trial. And counsel, once you file that motion, Ms. Ferguson will give you a date.
Yes, sure.
All right, you said there's brief impact.
Yes, ma'am.
All right. Are the parties here on Lozano? If you could start your video, please. Who's going to be the person?
It's Terry Kirkbride, Your Honor.
All right. Mr. Kirkbride?
Yes.
All right, you may begin with your impact statement.
Okay, I had no idea what to expect in this matter, but I see the sentencing's already been done. I'll just try to keep it short. I think the court's already heard most of our story, but I'll just go down the quick history. I mean, when we made our decision to move to Florida, it was to be near kids and grandkids. It was a pretty tough decision. I lived in California all my life up to that point. Sold our home, gave away pretty much all of our possessions that could be replaced, like furniture, refrigerators, that type of thing. All of our most precious items were packed up very carefully. It took us almost 3 months to get everything properly packed and wrapped. And I bought a 24-foot enclosed trailer, and that's where we packed everything in. On our journey to our joyous move to Florida to start a new life, we made it as far as San Antonio. And of course, from that moment forward, December 4th forward, it's just like our world was turned upside down. It derailed our whole joy of the move. And what was supposed to be looking for a home right away turned into almost an 8-month endeavor because we were dealing with all of the aftermath of the theft. I'm a combat veteran. one of my diagnoses is PTSD, so I was already dealing with that. And then this just totally derailed me and my wife and left us kind of in this state of like, what next? As we put the pieces together, keep in mind, it was 3 years, 3 months from the time of the theft to the time of the trial. And they had some 22, 23 resets. Each one of those resets represented to us is we had to juggle our lives around the schedule of the court. We gave up family vacations, gave up visiting sick family members. We did a lot of things during those 3.5 years, 3 years, 3 months that just kept this thing going. And now we're here at the final part of the sentencing and all that. And I feel for both sides. I feel for Mr. Lozano and how this must be for him. But I also got to understand what it was like for us. These weren't just things that you go to the store and buy. This was our life. My wife is a Native American studies. She had all of her research that was in those boxes that are gone, all of my VA records, all of our photographs of our family from the past, videos of the kids, all those things that cannot be replaced, along with all my military accolades that are gone. The impact was great. And I am glad that we're finally at a point for us anyways, where we can just kind of turn the page. I think that's enough said.
All right, thank you. And Deputy, you can take him into custody. What is his client's name? Marco Antonio Vasquez. All right, Marco Antonio Marino Vasquez.
We're ready, Judge.
All right, come down, sir. Yes.
We're gonna need the interpreter. Oh, she's here.
Can you do IDs read this at the same time as this one?
Mine's gonna be quick.
Yeah, I just have one set of. Headsets.
So,
Oh, okay.
All right, Mr. Marino Vasquez, you've received the plea offer from the state.
Yes, you gave me an offer.
All right, did you understand it?
La mera verdad no sé por qué me están ofreciendo eso. La mera verdad no sé por qué me están ofreciendo eso.
Honestly, I don't know why they're offering me
No,
that.
no, let me stop you right there. Here's the thing. You're charged with murder. That's what the state is offering. All I need to know from you is whether or not you received the offer. That's yes or no.
Yes, I did receive the offer.
All right, so are you accepting the offer, rejecting the offer, or do you need time to think about the offer?
No.
Rechazar o aceptar?
Rechazar.
Rejected.
All right, Ms. Ferguson, state how long will this jury trial last?
Judge, on this particular one, it's codependent.
Okay.
And so it doesn't have a lot of moving parts. So actually, case in chief, I'd imagine 3 A's tops, but that's not including jury selection or the punishment.
All right, Ms. Ferguson, it's going to be a week for a jury trial on Mr. Marco Antonio Marino Vasquez. And state, I know you have other murder cases upcoming.
Yes.
So if you want to speak to Ms. Ferguson.
And Judge, there's a codependent case. They may want to go on a codependent case first.
All right. Well, we'll put this down and we'll see who goes first. And Joseph Stateson,
Yes, Your Honor.
Monica Guerrero is on the co-defendant on this case.
I was hoping to announce after this announcement is finished.
Okay.
That's fine. I don't have any plans for them yet.
All right, September 3rd. Your jury trial date is going to be September 3rd. All right. You have any questions?
In 5 months?
Yes. And you'll be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to speak to your attorney and sign a clothing exchange.
I'll take care of that, Judge.
All right, thank you.
Thank you, Judge.
All right, thank you. All right, Mr. Stateson, are you ready on?
I am.
Okay.
Adis Rivas.
All right, Rivas Hernandez, come down. Rivas.
Judge, this is the co-defendant.
Okay. All right, Mr. Stateson, an offer was tendered to your client. Is he accepting or rejecting?
We received an offer. We conveyed it to him. The offer is being rejected. We're requesting a jury trial date.
All right, we'll put you for September 3rd.
September 3rd.
Yes, that will be your jury trial date. You'll be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you need to let your attorney know, and they'll do it at clothing exchange. Counselor, if there's an issue with the clothing exchange, just let the court know.
Yes, Judge.
All right, thank you.
Thank you, Judge.
Fernando Serrato. Oh, and Joseph Stateson, whenever you all are ready on that plea, just let me know. All right. Where is Fernando Serrato?
Custody judge,
Did you ask to have him brought out?
not yet, but it's a motion to revoke, and there are 2 new offenses alleged.
I require that they be brought out.
Okay, Judge.
Thanks.
I need to reset because there's a last.
Aria Frosto.
This is on. Hey, Garcia is gonna be.
Is this on the docket today?
Yes.
I don't.
She's on a bond right now.
Have a great time.
So I don't know what you want to do with that, but she's on an off bond, but this case, reason I feel it's even because of this pending mention called, it was put on probation. She hasn't reported yet, but she has.
All right. All right. Are you Karen San Miguel? All right, just one moment. All right, everyone. Whisper, please. Who's the attorney for Aria Eden Frosto?
That's Peter Calderola. He was here earlier. Good. I don't know where he's at.
He stepped away from him.
All right.
Here.
So, attorneys, I made this announcement at the beginning. And if people don't follow these rules, your day is going to get complicated. Do not request an inmate if you are not planning on staying in court. As you can tell, there are a lot of inmates in the box. For security reasons, we can only have so many inmates in the box at one time. All right, can I see the file on Karen San Miguel? And then next up is going to be Tyler Small. All right, this case has been dismissed.
Oh,
No problem. Oh, no, I just signed it.
okay, thank you.
And can you make sure that any warrants are recalled since it's been dismissed?
Yes, ma'am.
Thank you.
She has an off.
Okay, all right, thank you. All right, Tyler Stephen Small. Hello, this is for a motion to revoke.
Yes, Your Honor.
All right, could I have a motion to revoke stamp, please? That's fine, thank you. Okay, I'll pick that up. All right, are you all ready to proceed on the motion?
Yes, Your Honor.
Court is calling 2023 CR 0029, State of Texas versus Tyler Stephen Small. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Glenn Payne for the defense.
And are you Mr. Small?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Tyler Stephen Small who was placed on deferred adjudication in 2023 CR 0029 for the offense of injury to a child, intentionally bodily injury on August 24th, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
State.
Your Honor, on or about the second day of February 2024 in Bear County, Texas, the defendant, Tyler Stephen Small, did then and there fail to report to the supervision officer as directed in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
And Your Honor, the state will waive and abandon the others.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor.
And what is the proposed agreement?
Counsel.
Sorry. Your Honor, the proposed agreement is from probation. They stated a zero tolerance and roll and bip within 3 days, weekly drug test for 30 days on IVR line, followed by monthly tap and follow recommendations. I believe probation said that you don't do zero tolerance.
No, I don't. You're supposed to be doing what you're supposed to do.
So what I was going to request is Mr. Small had been about probably 7 days in jail.
It was a little over 2 weeks.
Maybe show that as a sanction in jail and follow the rest of the recommendations in this case. He is currently working at Chester's Hamburger. He is also enrolled in Lawson's HVAC technical school. He's currently doing very well there. He did, I think that you've already been informed that he did do a drug test this morning where he has tested positive for marijuana, but no other drugs. That's what we're gonna ask the court to follow this recommendation.
Probation?
Yes, Judge. The agreement that the state and defense have made is fine with probation.
All right. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. State your name for the record.
Tyler Stephen Small.
Why are you not reporting?
Honestly, I was at Taco Cabana and I had been smoking marijuana with my manager and I knew that I would fail the drug test.
All right.
And I thought that when I went in, I would be drug tested. And
So your answer, how old are you?
I'm 35 years old.
So you know you're not supposed to smoke marijuana. You did it anyway.
Yes, ma'am.
And you're doing it, I guess, while you're at work?
I was at Taco Cabana. When I got the MTR, I went to jail. I talked to my wife and we decided I went to do another job. We went to one that was 2 minutes away.
No.
Oh.
Here's the thing. You're speed talking. So you were doing marijuana at Taco Cabana.
Yes, ma'am.
And that is why the food has fallen off. So what was your job at Taco Cabana?
I was a cook.
Do you think anybody wants the cook to be smoking marijuana over their food? So you and the manager at Taco Cabana are doing marijuana.
Yes, ma'am.
and you decide you're not going to report because you're going to be positive.
Yes, ma'am.
See, you just compound your problem. So was he positive today?
Yes, Judge, it was positive for marijuana.
All right, so when did you use marijuana with the people at Taco Cabana? I'm assuming it's in February.
No, I used it up until the point of my MTR. I have not smoked since, but I was smoking every night with my manager.
All right. All right. What is his TAP evaluation? Did he have a TAP evaluation?
No, yet, not yet, Judge.
All right.
We are asking for the TAP to be complete and to follow all recommendations.
All right. Deputy, he's going into custody today. All right, this is what the court is going to do. Court will deny the motion, alter and amend conditions to include a TAP evaluation in custody, follow all recommendations of TAP. And if TAP recommends an outpatient treatment, then that's going to be 90 sober meetings in 90 days. And there's going to be a UA hotline for him until further notice. And while he's in custody too, we can do a referral to felony drug court. And to the clerk, he's going to be in custody for his TAP evaluation and for felony drug court referral.
Judge, if I may, he's no longer at the Taco Cabana job. He left. He has another job at Chester's Hamburger. He's not using marijuana anymore. They have 4 children they're supporting, and he is in a technical school that he's trying to better himself. He was able to get out of jail, post bond, and try to make better. Would the court consider allowing him to remain out to get these conditions done? You could even have him report, or we can have him report daily if you want to have a drug test. We'll show that his level is going down, but he's taking the first step on his own to try to make better progress. We're just going to knock him back
Okay.
a few more steps.
All right, we can go off the record. Here's the thing. Everybody who comes to this court on probation, what do I tell them? If you have an issue, pick up the phone, let probation know, because to be successful on probation, communication is key. I tell everybody that. I say, if you feel as they're not addressing that issue, you can come in and talk to the court. You didn't do any of those. What you decided to do, and you're an adult, it's not like although I know 18-year-olds, 19-year-olds are considered adult. It's not like you're an 18-year-old or 19-year-old or 21-year-old. You're old enough, you know better. And what you've been doing is been avoiding consequences. And these are consequences for our actions. Now, if you would like, I could send you to prison. So these are consequences for our actions. And what you've shown me is I can't trust you to even report for probation. That is why you're doing the TAP evaluation in custody. That is why you're doing the felony drug court referral in custody. What I can tell you, if felony drug court accepts you, today is Thursday, they'll probably see you by next week. You understand? There are always consequences for actions. And I think you're old enough to, when you make choices, you need to sit down and say, I'm making choice A. What are the consequences for that? You understand? And I don't write the rules for probation necessarily. This whole thing where you can't drink alcohol while you're on probation, even though alcohol is legal, that's not from me. That's from the legislature. This whole thing where you can't smoke marijuana, that's not from me. That's from the legislature. And I know people think, it's just marijuana. But look at you. You standing before me using marijuana every night at the Taco Cabana instead of making people's food properly, which is why I probably had some hair in my food. But you're doing that. And guess what? Going home smelling like marijuana with your children. And now you before me telling me you have children. Those are consequences you should have been thinking about. And you're on deferred adjudication for injury to a child. Do you understand? All right. Good luck to you. All right. Woodard. Hello. Anthony Woodard. Come forward, please.
Hello,
Hello.
Anthony is right here.
All right, so Mr. Kuntz, it's the court's understanding that you need more time?
Yes, ma'am.
Okay. All right, so on Mr. Woodard, this is going to be the last reset. So every witness that people need to call, you need to have them ready.
Yes, ma'am.
Ms. Ferguson, on Anthony Woodard, can I have a 30-day reset, please?
Perfect.
All right, there'll be no further resets. Both parties understand? So if people need witnesses for this, make sure they're here. Once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome.
I have one photo here.
All right, could I see the parties on Christopher Acosta?
He is outside, Judge. Let me get him real fast.
State. On Christopher Acosta, Mr. Kuntz is asking for a reset to have more witnesses. Are you all okay with giving him a reset?
Sure.
Oh, it's a DWI and he wants, more people to come in.
We're not opposed.
Okay.
Where, Judge? Sorry about that.
All right, Mr. Acosta, my understanding from your attorney is that he wanted further reset so that he can have more time to have more witnesses here. I'm going to give you May 23rd. There'll be no further resets in this case.
Yes, ma'am. That's fine.
All right.
Thank you.
You're welcome.
I'll bring the reset on.
Okay.
Thank you, Judge.
You're welcome. Who's here on Juan Carlos Rios?
Ready?
Come forward. Where's Mr. Rios?
She has it. I put the files up. I mean, I put it.
Judge, I always forget which side I'm supposed to stand.
Here.
Sanchez.
And that's at the request of the deputies. All right, so all the discovery has been received. Is that correct?
I believe so, Judge, yes.
All right, I need a acknowledgement of discovery. Done. State, were you able to tender an offer?
And Judge, we were just going to ask for a little bit more time. We did talk to defense just because this is a case that we are going to have to go to administration on.
All right, Ms. Ferguson, on Juan Rios, can you reset this for 45 days?
Thank you, Judge.
All right, on that date, you all will need to be prepared to tender an offer.
Yes, ma'am.
Thank you.
And likely, Judge, if we were able to go to administration earlier than that 45-day, we'll let defense know.
All
Make
right.
sure they're aware.
And then just set it on the record. Thank you for dressing appropriately for court.
Thank you.
All right, what date, Ms. Ferguson? All right, we'll be back on June 3rd.
June 3rd. Thank you, Your Honor.
All right, you're welcome.
Yeah.
Who's here on Ramon Sanchez?
Here, Your Honor.
Ramon Sanchez, come up. I think so. They're coming up. All right, what is happening with this case?
Your Honor, he has a newer indictment that he was indicted about 3.5 weeks ago on a
Yes.
case that I haven't had an opportunity to really review the discovery in that case.
All right, and so are you on all cases?
I'm on both cases.
All right. Ms. Ferguson, can I have a 30-day reset on Ramon Sanchez, please? All right, we're going to come back on May 23rd. State on May 23rd, an offer will be due.
Yes, ma'am.
All right, do you have any questions, Mr. Sanchez? All right, we'll see you back on May 23rd.
Thank you, Your Honor.
You're welcome.
Budget.
Yeah, that was Ramon Sanchez. Jesus Lopez.
Morning, Judge.
Good morning. Are you all ready to proceed?
Yes, ma'am.
Court is calling 2023 CR 8930, State of Texas versus Jesus Lopez. Can I have parties announced for the record for the state?
Casey Garahan, Your Honor.
Defense,
Travis Kettner, Your Honor, we're ready.
are you Mr. Lopez?
Yes, Your Honor.
I'm showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Jesus Lopez who was placed on deferred adjudication in 2023 CR 8930 for the offense of evading arrest detention with vehicle on November 16, 2023 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violated condition number 4 in Nueces County, Texas, the defendant Jesus Lopez did then and there failed to report to the supervision officer for intake as directed for the date of January 16, 2024, violation condition number 4.
How do you plead to that? True or not true?
True.
Do you plead true?
Yes, Your Honor.
We'll waive the remaining violated conditions.
Any objection?
No, Judge, thank you. We just have an explanation whenever the court's ready. No.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
And that is to deny the motion, continue the individual on his deferred with the admitted condition of residential treatment with state ISF.
All right, is that the agreement?
Yes, ma'am, it is.
Are you asking me to follow that agreement?
Yes, Your Honor.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Jesus Lopez,
All right, so Mr. Lopez, how old are you?
18.
All right, so what is going on with your life? Why are you not reporting?
Your Honor, I got sick and I did report, but I reported through the phone and let my probation officer know that I was sick. She said it was fine. I told her I could go in a couple of days because when I'm not sick no more, she said it's fine. And she rescheduled me for a month later. And I was gonna go to report, but I ended up getting arrested for it.
All right, so what was your illness, if you don't mind me asking?
I have no idea. It was more than likely the flu.
Okay. Do you have family in Nueces County?
Yes.
All right. All right, this is what the court will do. The court will deny the motion. Alternate amend conditions for ISF substantive track. And have you been using marijuana?
I don't use no drugs, Your Honor. You can-
All right. So we'll do it for substantive track. Or are you being 100% honest with the court?
I don't use no drugs, Your Honor.
No marijuana?
No marijuana. You could drug hair follicle from me, anything.
Okay. Probation? Mr. Lopez is saying that he hasn't been using drugs, so we'll do ISF cognitive.
And he has been in jail for approximately 2 months, Judge, so
All right. Is there anything else?
no, thanks, ma'am.
All right, we can go off the record. Ms. Ferguson, can you do a phantom date on this? 30 days, and let's see if he's been, yes?
The wait for state ISF, and they know this is at least 40 days. So if we do a phantom date, it's gonna be like 45 days.
All right, let's do 45 days. All right, let's go back on the record, please. Mr. Lopez, you understand that the wait time for ISF cognitive, that means that there is approximately a 40-day to 50-day wait. Do you understand that?
Yes.
And do you still wish to wait for transfer at the jail to ISF Cognitive?
Yes.
All right. All right, thank you. If there's any other issues, let the court know.
Thank you.
And we're going to put you to come back to this court on June 3rd. It's not going to appear in the system because if it's in the system, then it'll stop you from being transferred. But that's just for me to make sure that you appear, okay? And that you transferred.
So they don't lose track of you.
All right, thank you.
Thank you, Judge.
State, on his, what is happening with those other cases?
I was notified by the defense. I haven't touched this out, but it's, the case works.
Well, I wonder if we should be doing IS cognitive. Maybe it should just be reporting weekly.
I don't know what other issues were, but the other indication was like you're acting to reputation. I mean, I thought it was more extreme, so.
Yeah, okay. All right, thank you. Okay, this is done. Who's Fausto?
Is that NTR that you called?
Oh, okay.
I apologize that I wasn't here when the case was called. I think there was just miscommunication about, I was just running downstairs and coming back upstairs. I'm sorry, Judge.
All right, so here's the thing. I made this announcement at the very beginning that when you ask for someone to be brought out when they're in custody, because there are only so few people that can be brought out, then when you leave, you're being selfish to the other colleagues.
I understand, Your Honor. I apologize.
All right.
I won't make that mistake.
All right,
Sorry.
thank you. All right, who's here? Mark Renee Hernandez. All right, if you come forward. Yes. Let me ask you this, because this is a request for early termination. Has he done a UA?
Yes, he was clean, Your Honor.
Okay. All right, you can unfold your hands. I've never been to Chicken Express.
It's over there by Stone Oak area. It's kind of far from here.
Is it good?
Yes.
Okay.
I'm the general manager, so I take pride in it.
State on Mark Renee Hernandez. He's done a UA. He's negative. Do you have any objections to early termination? Have you had a chance to review it?
No, Your Honor. No, I haven't had a chance to review.
All right, if you'll confer with them, he's on probation for marijuana.
Judge State has no opposition.
Okay, and did you confer with probation too?
I did, yes, Your Honor.
All right, and did they have any objection?
Not that I was aware of, Your Honor.
All right, what have you learned since being on probation? Don't come back here again?
Yeah. Pretty much just not doing the thing. Well, honestly, when I first got put on, I was going through a tough time. Like my dad had just passed and, stuff was just difficult for me, but it's been 2 years since then. So coped with it, doing much better in life now than I was back then. So.
All right, that's awesome. I'm glad you did very well. Whenever people are placed on probation, I know the state is hoping that you complete everything. I'm hoping that you complete everything and you're successful. So congratulations. I've signed the motion to terminate you, so you are done.
Thank you.
Terminate sounds like such a bad word.
In this case, it's not a bad word.
All right, have a great rest of the day. Don't go out celebrating, okay?
Thank you, Judge.
All right, bye-bye. Probation on Mark and Renee Hernandez. Early termination is granted.
Can I get a copy of the order?
Oh, sure. Just get it from the clerks. Aria Frosto. Court is calling 2023 CR 0168A, State of Texas versus Aria Eden Frosto. Could I have parties announced for the record for the state,
Hank Wilkins for the state, Your Honor.
defense?
Peter Calvarola from Ms. Frosto, Your Honor.
And are you Ms. Frosto?
Yes.
Counsel, did you, I'm sorry, Ms. Frosto, I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Aria Eden Frosto who was placed on deferred adjudication in 2023 CR 01688 for the offense of burglary habitation on May 1st, 2023 for a term of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 42 in Bear County, Texas. The defendant, Aria Eden Frosto, did then and there fail to report to the supervision officer as directed for the weeks of September 25th, October 2nd, October 9th, and October 16th, 2023, in violation of condition number 42.
How do you plead to that? True or not true?
True.
And Your Honor, oh, sorry.
Do you waive?
Yes, ma'am. We waived the other violation alleged in the motion.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 42, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? You need to speak up.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 42?
Yes, Your Honor.
Court will find violation of condition number 42 true. Is there a proposed agreement?
There's not, Your Honor. The state is asking for a cap of 8 years in the prison, and I know the defense wants to ask for something else, Your Honor.
All right, defense, what are you requesting?
Yes, Your Honor. My client is requesting that, respectfully requesting that we possibly continue on probation.
Okay, you're gonna need to speak up. And everyone, you need to whisper. We're on the record. And if people are having reunions instead of chatting about cases, I'm gonna ask that you hold off on your reunion talks. Yes.
Your Honor, respectfully, my client is requesting that she be reinstated on probation and subject to any programs that the court might deem appropriate. My client would also like to address the court if.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Aria Eden Frosto.
All right, what would you like to say?
I stand before you today to ask you to reinstate my probation and or give me a monitor to show you that I've matured since being 17. While being incarcerated, I have been working on my GED. I've also taken anger management courses and I've had good behavior since being incarcerated and always try to behave myself even on the outside. For being only 19, I am very mature for my age and I know I have a lot of potential. I also know my worth as a mother and a young woman. When it comes to being a hardworking, sophisticated woman, I plan on going to college when I am released. Also to do is what I need to for probation. I have an interest in cosmetology and I'm pursuing that as my career. I have a 3-year-old son that needs me at my best version of myself and looks up to me. I have 2 younger sisters, 14 and 13, that also look up to me as well. Since being incarcerated, I missed my son's 3rd birthday and my sister's 13th birthdays. They mean
Okay, let me stop you for a moment. So the main question for me is, why are you not reporting? This whole thing about you missing your son's 3rd birthday and your sister's 13th birthday, that's all on you. So why are you not reporting?
I had a very hard life growing up. I haven't had parents. I haven't known right from wrong most of my life.
So let me ask you this. When is it your choices and it's not the fact that you had horrible parents? When does it become your choice?
No.
When you're 30? And then it's no longer, you can say, well, I had a bad childhood. My parents were horrible. My parents didn't raise me.
I know you're not.
So when does it stop being your parents' problem or your parents' fault? When is it because you're making choices?
I've made very bad choices.
No, I mean, my question is, how old are you now?
19.
All right, so my question to you is, when is it, woe is me, my parents were horrible, when does it become, it's a choice you made?
Right now, Your Honor.
No, when?
This choice.
When? Because what you're reading, you're giving me excuses as to why you didn't report. Your excuse is you don't know right from wrong, which I don't understand how that's even possible. But your excuse is I don't know right from wrong because I didn't have any parents to teach me right from wrong. And you're 19, correct?
Yes, Your Honor.
So at what age will you stop making an excuse that I don't know right from wrong because my parents didn't teach me? What age will you be when you won't come before another court or somebody else using that as an excuse? Tell me.
I'm sorry, Your Honor, it stops now.
All right, so here's my other question. Why are you not reporting?
I had no transportation and I was trying my best. And I called him multiple times telling him my circumstance, and that was my probation officer.
Let me ask you this. Were you eating food? You need to say yes or no.
Yes, Your Honor.
So did you have a job?
No, Your Honor.
So how were you supporting yourself?
As best as I could.
No, what does that mean? How were you eating and supporting yourself if you didn't have employment?
I had my mom, but
all right, so you had your mom, the same mom who's a horrible parent who didn't teach you right from wrong, correct?
I chose her as my mom. She adopted me, but they had already said I had warrants out.
So were you living with her?
Yes.
And where is your 3-year-old?
He's with me and his dad. Back and forth. I see him on the weekends.
All right. So this is what I'm looking at. When this plea bargain was done, there were many cases that were taken in consideration. Have you paid any of the restitution?
Yes, Your Honor. I paid it when I went to probation the first time. I was paying my probation fees were $80 a month, and my drug fees, and I never came out dirty.
I mean, I just don't understand. You're not reporting. I don't understand that. I know this is your second motion to revoke.
Yes, Your Honor. But
So,
I want
I
to
mean,
change that. I really do. I want to change that.
All right. So I'm sorry, but you're not a good candidate for probation.
Yes, Your Honor.
I mean, this is your second time. You've been given chances. I don't think there's anything else that the court can do for you. I mean, I don't think she has any prior history that would exclude her from potentially a shock probation, but I'm going to find her guilty. And as previously stated, I'm finding violation of condition number 42 true. There's to be no unsupervised contact with minors. And I'm going to sentence her to 5 years in the prison. Give her credit for any time served. Probation, is there outstanding restitution?
I don't have any restitution.
Okay. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, you do have a limited right to appeal, and that's as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand?
Yes.
All right, and I will tell you this, if we can go off the record, if you want me to consider shock probation, when you're at the prison, you had better be doing something to show me that you're making improvements and that you're internalizing the reason why you were sentenced. Do you understand?
Yes, Your Honor.
All right, and you can talk to her about shock probation.
Yes, sir.
Thank you. And I'm sorry, everyone, I'm going to need to take up the case involving the interpreter. It's Angel Martinez Pacheco. All right, if he'll come down.
Come on over. Yes.
And then after this, I'll take up the motions that have been presented to the court. Court is calling 2023 CR 11298, State of Texas versus Angel Martinez Pacheco. If I could have parties announced for the record for the state.
Frank Wilkins for the state.
Defense.
Attorney record is Monica Guerrero. Mr. Pacheco, will you give this judge permission for me to do this in place of Ms. Guerrero?
Yes.
All right. And are you Angel Martinez Pacheco?
Yes.
We have an interpreter here today. Could you raise your right hand? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams.
All right. Mr. Pacheco, all of the documents that have been presented to the court are in English. Were those documents explained to you in Spanish?
Yes.
Counsel, have you received all the discovery?
Yes, Your Honor.
And did you review that with your client?
Yes, we have.
Court will find that the state is in compliance with discovery. Mr. Pacheco, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and did you sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Pacheco, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand that you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Martinez Pacheco, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, has your client had access to an immigration attorney?
Your Honor, we had advised him of immigration consequences previously, Monica Guerrero and myself. And he was brought in previously on a different court date so that Monica could speak with him. And he accepted an offer and gave Monica permission for me to do this in place of her. He understands those consequences and wishes to go forward.
All right, Mr. Martinez Pacheco, did you understand by entering a plea in this cause number, it will have an impact on your immigration status?
Yes.
Did you understand that that impact could be deportation?
Yes.
The denial of naturalization?
Yes.
And the denial of re-entry into the United States?
Yes.
And did your attorney speak to you about the consequences of the impact a plea in this case will have on your immigration status?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's a $600 fine, affirmative finding of deadly weapon. State recommends deferred adjudication, and there's to be restitution, if any, to Marvin Tisa, T-I-S-A. Did you understand that to be the plea?
Yes.
State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your supervision be for a term of 8 years. There be a TAP evaluation, 120 hours community service restitution, and no contact with Marvin Tissa. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, I offer State's Exhibit 1 and the attachments.
Any objection?
No objection, Your Honor.
And state, have you spoken with the complainant?
We have, Your Honor.
And is the complainant aware of this agreement?
Your Honor, Daniel Escobar from the state of Texas, from our notes, it indicated that he did have a problem with the status agreement.
All right, thank you. All right, you may continue to confer. Mr. Martinez Pacheco, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it at all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We ask that you follow the plea bargain agreement. Prior to him being picked up in the Bexar County Jail, he was employed. He will need a payment plan for any fine, supervisory fees. However, he did indicate that he wishes to return to the address listed on the police report. And I had admonished him that he couldn't have any contact with Mr. Tiza. Just so that the court's aware, he may not have a place to stay. His other relatives are living in Mexico. So he doesn't want to violate probation going to an address.
All right. Does he have an immigration hold or no?
He does not, Your Honor.
All right. This is what the court is going to do. Court is going to sentence you to 10 years deferred adjudication, a $600 fine. That'll be probated. There's to be no contact with Essex, ESSEX Street, San Antonio, Texas, 78210. There is to be no contact with Marvin. It's listed in the plea bargain agreement as TISA, and the police report is TISTA. So there's to be no contact with Marvin Tisa or Tista. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Is he here legally?
My understanding, no, Your Honor.
All right. He is, I can't order deportation because this is state court, but he is not to come back to the United States unless he's here legally. So why do they not have for him to be deported if he's not here legally? All right. He's not allowed to, you're not allowed to be in the United States. That's a part of your probation. Probation, he's not here legally. He's not allowed to be in the United States. If he is here in the United States, then issue a motion to revoke. All right, so he's not allowed in the United States unless he's here legally. Field visits once a month until further notice. And I'm going to do a 180-day jail sanction. And that's to be day for day. And there's no credit for that. Anger management. Probation, is there anything else? All right. Is there anything else you need from the court?
No.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargaining, I'm sorry, there's also an affirmative finding of deadly weapon. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, thank you.
Your Honor, before we go off the record.
Yes.
if You could perhaps hold one turn in advance about his residency until there's perhaps violations
You mean about where he can't live?
about the residing in the US.
No, I mean, he's not here legally. If he's here legally, then of course I would do something different. But he's not, being in the United States illegally is a crime. And so he would be violating his probation. All right, thank you. Thank you, Mr. Statesman. All right, who's here on Luis Franco? All right, Mr. Franco, I have a dismissal. Mr. Franco, make sure that you're registered. They're dismissing the case for insufficient evidence. You understand? All right, thank you.
Thank you, Judge.
You're welcome. Who's here on Kevin Young? Yes. Thank you. Thank you so much.
On a docket matter, we are set for trial on May 14th.
Wait a minute, is this off docket?
Yes.
Okay, just give me a moment.
Oh, okay.
Sure. Who's here on Victor Garcia?
I am, Your Honor, we're ready.
Who's your case? Is it here?
Yeah, I did a motion.
All right, Mr. Jimenez, I'll take you up after this case. Thank you. Court is calling 2024 CR 1129, State of Texas versus Victor Mel Garcia. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Todd Lessert for Mr. Garcia.
All right, are you Mr. Garcia?
Yes, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have and I did.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're waiving the habitual offender enhancement allegation, but otherwise we're proceeding as presented.
Any objection?
No objections, Your Honor.
Mr. Garcia, did you review the document entitled Court Admonishments and Defendants Waivers and Defendants Waivers and Affidavit of Admonitions?
Yes, Your Honor.
All right. And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with felon in possession of a firearm? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison, and the state is remaining silent on your application. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Sir, not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer State Exhibit 1 in all attachments.
Make
No
it to your
objections.
Did you review the document entitled Waiving Consent to Stipulations of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Okay. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, and we'll set this for sentencing. What date? And we're off the record. Is there any? Yeah, it'll probably be best to do a sentencing. I mean, to set it for a PSI and a TAP.
Yes, Your Honor.
All right, June 17th, that's the earliest we can get your TAP evaluation done and the PSI done. I'll base my decision on whether or not to grant your application based upon the PSI report and any other evidence that's presented.
Thank you.
All right, thank you for dressing appropriately for court. If you'll make sure that you sign a reset form and visit with probation before you leave.
Thank you, Your Honor.
All right, you're welcome. All right, Joe Angel Flores. All right, we're here for a motion to modify conditions. Is that correct, counsel?
It is, Your Honor, I'm sorry.
All right, is the complainant here? I think she's by Zoom.
She is, Your Honor.
All right, let me have her zoom in. Court is calling cause number NIGHTMAG 751570, State of Texas versus Joe Angel Flores. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Tony Jimenez for Mr. Flores, Your Honor.
And are you Mr. Flores?
Yes, ma'am.
All right, we're here on a motion to modify conditions of bond. The court has been presented with an affidavit for non-prosecution and also the motion to modify bond conditions. State, have you had a chance to review?
Yes, Your Honor, I have.
All right, do you have objections?
I have no objections pending, of course, a discussion with the court and with the complainant where she articulates kind of her wishes and desires, Your Honor.
All right, Ms. Flores, if you'll unmute, please, and start video. Can you raise your right hand for me, please? Do you solemnly swear the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. State your name for the record.
Samantha Flores.
All right, court reported that's Zamantha. All right, who would like to question the witness?
Counsel, do you mind?
Well, let me ask you, you did approach me specifically about asking the court to modify this condition of no contact. Is that correct?
Yes, that's correct.
And presently, your husband is incarcerated and he also has a glue warrant pending. Is that correct?
That's correct.
And what is the importance of you communicating with your spouse at this time, knowing that he will not obviously be released until this case is resolved?
Well, we share 5 kids together, and it's hard to be able to see him, talk to him without him getting in trouble. We haven't spoke at all. And my children been asking for their dad, and well, due to us not being able to contact, it's really hard, and it's very important for that we talk to him, because like I said, like those are his kids too.
And is that the basis for requesting the court to modify to allow you to have these conversations with your husband?
Yes. Also, because I don't fear that he'll harm me.
Judge, I have no other questions.
Any questions?
No, Your Honor.
All right. I have some questions. So with regards to this case, are you the person who called the police?
Yes.
All right. And are you employed?
Yes.
Do you have parents who are helping you with your children?
Yes.
All right. All right. Thank you so much for coming in to testify. I appreciate that. All right, State, what is this case about? I have no idea if there were injuries or what.
I am happy to report back on the nature and extent of the injuries, Your Honor. This was.
Any objection?
No, Your Honor.
Okay.
And then once I report back to you, I can give you some further kind of clarification on that.
Oh, you're not prepared to do that now?
I am not. No, Your Honor. This is, as of course is noted, just a NIGHTMAG case, not a very old case. So I would need to pull up e-discovery to kind of get a more robust answer for the court, as opposed to like just our notes in a database.
All right. So, counsel, once the state is able to pull up a police report, or if somebody has a police report, just come back up and I'll make a ruling.
Yes, Your Honor.
All right. Thank you so much. And thank you for your patience. You're always patient.
Yes, Judge. Thank you. Judge, can I have your permission to leave for at least 30 minutes?
Yes. Oh, yes.
Okay. Thank you, Judge.
All right. And Deputy Laura, we're not done with Mr. Flores.
Have a seat, sir.
Ralph Orespi. Is he in? All right, today is plea deadline date, counsel.
Yes, Your Honor. We had received a plea offer. I spoke with my client about this, and I conferred with Zach quite a bit this morning. We proposed a counter. Zach made a second offer.
Okay.
I've spent time talking to my client. He just wants the weekend, a few extra days to think about it. Can we recall this to next week?
All right, Ms. Ferguson. Are you able to recall this for, I'm not going to be here next week. So, I mean, if you want it recalled next week, it can be, or if you want it the week of the 29th, it can be recalled the week of the 29th.
The week of the 29th is appropriate.
All right, what date, Ms. Ferguson?
May 2nd.
All right, May 2nd will be your plea deadline date. Thank you for dressing appropriately for court.
Thank you, Judge.
You're welcome.
Thank you. See, I'll go through this.
Garciano Villanueva. Court is calling 2022 CR 2866, State of Texas versus Garciano Agan Villanueva Jr. If I could have parties announced for the record for the state.
Jason Garahan, Your Honor.
Defense,
Colin Wilson for Mr. Villanueva.
are you Mr. Villanueva?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Garciano Agan
It's Ugin. Yes, ma'am.
Villanueva Jr., who was placed on deferred adjudication in 2022, CR 2866, for the offense of possession of a controlled substance, penalty group 1, 1 gram to 4 grams on April 18, 2022, for a period of 5 years. Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 1 on or about the 11th day of March 2024 in Bexar County, Texas. The defendant, Cristiano, again, Villanueva Jr., committed the offense of possession of a controlled substance, a violation condition number 1.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated conditions.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
No, there's not an agreement, Your Honor.
State, what are you requesting?
The state is requesting a revocation, and since he did play true to number 1s, the state is taking into consideration cause numbers Nightmag 755-399 and Nightmag 755-398. And we'll tender those to the court.
All right, defense, what are you requesting?
Your Honor, we are requesting consideration to deny the motion and continue him on deferred and follow the recommendations of probation, which include basically a repeat of SATF with the aftercare and all of the programs after that. Mr. Villanueva completed SATF, apparently received 2 certificates, did well, mentored while he was in there. Very optimistic when he was released, but unfortunately he wasn't prepared for life after being released. And whenever he returned home, some of the problems that landed him in SATF to begin with were still there. Primarily a girlfriend who used drugs and was not very responsible. He ended up being homeless when he tried to remove himself from that scenario, and then life spiraled and he relapsed. And so he's not here saying I shouldn't be held accountable. He's here saying he needs help. He originally came to San Antonio to try to get visitation with a young child. He had a job prior in Alabama that transferred him here. He had a life. He had hope. He had no criminal history. And just because of affiliation with people who led him down that road, he has a heroin problem. And he wants help. He continues to see a future for himself. He now has some additional family. He has an older daughter that is in Killeen now. She had been out of state, that they've reconnected and is offering assistance. And he has at least a plan for how he can live his life and stay on track and stay clean. And so we're asking the court to deny the motion and follow what probation is recommending and give him a chance to get clean and off the drugs.
All right, probation.
Yes, sir.
On this case, what are you requesting?
Judge, the recommendation would be for status, followed by the full track, followed by aftercare, weekly UAs for 60 days, monthly UAs, therefore, for the duration of probation or revocation.
All right, here's my question, State. The cases that you took into consideration, are those possession cases?
Yes.
Okay,
Judge,
yes.
I would like to point out that after being released from status, we have not had any communication with him.
All right. And can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record.
My name is Graciano Elgin Jr. Villanueva.
All right, when you were released from SADC, why didn't you contact your probation officer?
Upon being released, I mean, I've never been arrested before, so when I was released, I just I went to my girlfriend, and she's a heroin addict as well.
No, here's the thing. Did you not know you had to report?
Yes, ma'am.
So why didn't you report to probation when you were released?
Because right when I left from here, I went right back to doing drugs with her.
All right, this is what the court is going to do. The court is going to find number one true. The court will find you guilty, sentence you to 4 years in the prison, give you credit for any time served. I'll recommend the therapeutic community for you. Take in consideration NIGHTMAG number 7555399, 7555398. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
You do have a limited right to appeal, and that's as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand?
Yes, ma'am.
All right, good luck to you. Cam Lee. Hello, how's it going?
Good, how are you today?
All right.
Good.
So what's going on with Mr. Lee?
So we have great news. Daniel and I have come up with a plan where he is going to apply for child diversion. So Mr. Lee was actually sitting there working on the application while waiting to be called up. So we submitted today.
Okay, awesome. Norma, I need a reset for PTD. All right, so you're going to come back here on May 16th. It's just to make sure that everything is in order. You understand?
Yes, ma'am.
All right, and if you need anything, you can always come back to this court. All right, thank you for dressing appropriately for court.
May we be excused?
Yes, once you sign the reset form.
Of course, thank you.
Fernando Serrato.
Yes, Your Honor.
Are you all ready to proceed?
No, Your Honor.
What's happening?
Requesting a reset. Mr. Strato, there are two number ones alleged in the motion to enter adjudication of guilt. They do not have lapse back yet on one of the number ones, which is an accusation of alleged possession of controlled substance, penalty group 1 less than a gram. Also, Mr. Strato has some immigration issues. I have not heard back from the MAC yet regarding the Padilla situation.
All right. All right, Norma, on Serrato, if you can make sure that immigration is aware that he needs counseling for immigration. And you speak English, correct?
Yes, Your Honor.
Okay. All right, Ms. Ferguson, recall this for a contested in 45 days. If it turns out it's not contested, then we'll go from there.
Yes, Your Honor. And if that is the case, I will continue conferring with the state once I get the information that I need to do my diligence, Judge.
Okay. All right, June 3rd.
May I be excused, Judge?
Yes.
Thank you, Your Honor.
You're welcome.
I'll get another Zoom visit with you once I find out. Okay. Thank you.
Lee Andrew Martinez. Oh, where's he?
So on a motion to set bond, you asked us to file a motion, written motion.
Okay.
We have an agreement.
All right, court is calling 2021 CR 7016, State of Texas versus Lee Andrew Martinez. Could I have parties announced for the record for the state
Hank Wilkins for the state, Your Honor.
defense?
Warren Wolf, Mr. Martinez.
All right, so and you're Mr. Martinez?
Yes, ma'am.
All right, a bond forfeiture was entered because you did not show for court on December 10th, 2021. I'm sorry, yes, 2021. So where has your client been?
In San Antonio.
All right, so what are you all stating for a bond?
We agreed to a $2,000 bond, Your Honor.
There were two cases, $2,000 in each.
All right, I only have one.
I gave.
No, I have a,
She's got the other.
okay. Oh.
9488, 9487.
All right, and the court is also calling 9488. So do you want to present any information about your client's ability to make bond?
Judge, he is working, he's.
I mean, you want to call him as a witness, or are you all going to just do a proffer?
I'll just proffer.
All right, any objection to the defense doing a proffer?
No objection, Your Honor.
All right, yes.
He has a job. He was working before he was picked up. And that's another matter. But the point is, he's working. He can make the bond. His girlfriend's on the outside and she'll help him. And he needs to get back to work. That job is waiting for him.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Lee Andrew Martinez.
All right. Are you employed?
Yes, Your Honor.
Where have you been since 2021?
I've been at the same residence that is provided, 405623 Randolph Boulevard.
All right. And what do you do for work?
I'm a car salesman.
Okay. Did you not know about this setting?
At the time that it happened, I was unaware. And when I got the information in the mail, it was past due. So I missed the court date.
All right, so where have you been for 3 years?
I've been at that address.
No, I mean, with regards to this case, were you arrested? Did somebody find you? What happened?
I got arrested. That's how I'm here now.
On another matter.
Oh. When you say arrested on another matter, what is this other matter?
Family violence assault.
And who is the complainant in that?
Was that?
I've talked with her, Judge.
No, what's her name?
Was that?
Lizette what?
De La Rosa.
How do you spell the first name?
Lizeette.
Last name?
Delarosa.
And what is her relationship to you?
She's my girlfriend.
And is this the person you're currently or you want to live with?
We're not living together. I live with my mother.
All right. So what's the bond on that case?
$5,000, Your Honor.
All right. So what's his criminal history?
He does have a, excuse me, Judge, I printed this out.
No problem.
He has a possession of marijuana from 2008. That's a felony. And in 2014, he had a DWI with child under 15. I'm sorry, did I say 2014 for the second one, for the DWI? And an obstructing a highway in 2013, Your Honor.
All right, this is what the court is going to do. In each case, the court will grant a bond. Bond will be set at $6,000. In each case, there's to be no contact with Lizette De La Rosa. There's going to be partial GPS for work only. There'll be random UAs, waive fees. All right, thank you.
Thank you.
And when is this set? When is our? All right. Kevin Young.
Did you copy?
Frederico Ojeda. Who's here on Frederico Ojeda? Come forward. No, I forgot to read your CV. All right, what's happening with this case?
First setting, I do have discovery. I'm gonna supplement my request to ask for disclosures. There was some disclosures regarding the officers that we asked them because of that.
All right, state on this case, he says he's going to ask for disclosures.
Sorry, Judge.
On this case, Frederico Ojeda,
Yes, sir.
defense counsel said he's going to ask for disclosures.
Okay.
Also, Ms. Ferguson, on this one, can we have a 45-day reset for discovery? And counsel, if you'll let the state know which officers you're requesting disclosure so they can work on that.
Yes, sir.
All right. Thank you for dressing appropriately for court. Once you sign the reset form, you are excused. You're welcome. Number, what page is he on? All right, thank you. And what date did we set Kim for? Lee? All right, thank you. Jerry Torres. Who's here for Jerry Torres? Okay. All right, today is, you're on this side, counsel.
Sorry, Judge.
No problem. Today is plea deadline date. Where are we?
We haven't reached the plea bargain, Judge.
Okay. State, how long do you expect this trial to last?
Maybe 2 or 3 days.
All right, Ms. Ferguson, this is criminal trial division, 2 to 3 days, jury trial.
Excuse me.
You sound ill.
I'm actually getting better. I don't have much of a voice, Judge.
I was like, are you all still gonna have your fiesta?
Of course.
I would love to be there. I can't, I'm gonna be with mom.
Oh, well, that's good. That's
Yeah.
better though.
Yeah,
Yeah.
I always enjoy the fiesta. Last year I was able to make it. You guys changed dates on me.
Oh,
Did
well,
y'all
they
change
changed
dates so I wouldn't appear?
No, they changed dates of Fiesta.
No, they did.
It's late.
Yeah.
I guess they're concerned with Lent.
Ah.
Yeah. Judge, we might be able to have a dispositive motion to suppress. Do you think we could have it next week?
I will not be here next week,
Okay.
but state, on this case, it's a DWI.
Yes, it is, Judge.
He's saying that the motion to suppress will be dispositive.
So he's gonna plea if it's not granted?
Yeah, that's what he's saying.
Okay, Judge.
But he's saying next week, I'm not gonna be here, and I know you all have other things. So, Norma, they want to have a motion to suppress. Is there a day that you all have impact?
There is, Judge.
Okay. Can you put it for a motion to suppress then with impact maybe, or either you can do it with me?
If who's here next week, Judge?
Oh, they're not gonna be able to do it next week.
Okay.
It's Angelini.
And we're gonna be at trial next week.
Yes.
with the head judge. I think impact, we don't have it until the 20th of May, is that correct? Or is that family violence?
Yeah, it's you all.
So May 20th? All right. All right, thank you for dressing appropriately for court. I appreciate that. Once you sign the reset form, you are excused.
Thank you.
All right, thank you. Hope you feel better.
Thank you, Judge.
Who is here on Renee Cantu?
I'll call him right now.
All right.
Yeah.
Then that's gonna have to be taken up in the afternoon.
Yes, ma'am.
Tuska Hamrick. And Mr. Stevens, don't worry, I'm gonna get your motion.
Thank you, Your Honor.
All right, court is calling 2022 CR 8246, State of Texas versus Tuska Hamrick. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense,
Brian Kimbrough from Mr. Hamilton.
probation, this is an application.
Oh, Judge, I'm sorry to interrupt, but it's Jason Garahan for the state.
All right, thank you. All right, are you Mr. Hamrick?
Yes, ma'am.
Counsel, have you received all the discovery?
I have your.
State will find that this, court will find that the state is in compliance with discovery. Mr. Hamrick, did you review the application for deferred adjudication and community supervision
Yes, Your Honor.
with your attorney? Did you sign it?
Yes, Your Honor.
Did you review what's entitled true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are. We're proceeding on each count, Your Honor.
All right.
Which they're all the same.
So it's 1, 2, and 3?
And 4.
And
There should
4.
be another page, Judge. I don't remember.
All right. Mr. Hamrick, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault with a peace officer or judge in counts 1, 2, 3, and 4? Those are second-degree felonies. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargaining agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 20 years in each count and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hamrick, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,000 fine. State is recommending deferred adjudication in each count and an anger management course. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainants. Did you understand?
Yes, Your Honor.
Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Sure.
Then to count 1, how do you plead?
No contest.
Count 2,
No contest.
count 3,
No contest.
count 4.
No contest.
State any evidence.
Yes, Your Honor. In each of the counts, state exhibit number 1 with attachments.
Any objection?
No objection.
And state, are the complainants aware?
Yes.
All right, thank you. You may continue to confer.
Thank you.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilty as you've applied for deferred adjudication. Are you asking to proceed with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. I'd ask the court to follow the plea bargain. Hamrick is 24 years old. He has no criminal record. He's a resident of Oklahoma. He lives with his parents in McCurtain County.
How do you spell that?
McCurtain County. And I would ask that his supervision be transferred to McCurtain County. I've spoken to his family. This is not characteristic of Hamrick. He is employed, works with his family, never been in trouble. And I believe he can successfully complete probation.
All right. So who is Marco Antonio Gonzalez to you?
I don't personally know him. It was,
Were you intoxicated? Because I don't understand. According to this, you were asking him to get out of the vehicle.
I was intoxicated at the time.
Okay. All right. The court will sentence you to a $1,000 fine that will be probated. 10 years deferred adjudication. Counts 1, 2, 3, and 4 are to run concurrent. There should be a transfer to McCurtain County in Oklahoma. You're not transferred until they accept the transfer. Regular reporting by Zoom or in person. Regular random UAs. Probation, will they accept a transfer while he's in custody or no? All right, there should be no contact with M. Butler, C. Heron, Herron, S. Gatan, Sgatten, S. Shurtleff, that's Shurtleff, Laura Hernandez, Arizona Garza, Marco Antonio Gonzalez, and 4620 Thousand Oaks. And that's San Antonio, Texas, 78233. TAP evaluation in custody, probation. If it's discovered that they won't accept him till he's released, then he can be released. Follow TAP Rex. proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Field visits, one time per month for 3 months. And an anger management course. Probation, is there anything else he needs? All right, is there anything else you need from the court? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. You're gonna have to make better decisions. Otherwise, you're gonna find yourself in and out of custody. It appears that you have a drug or alcohol problem. If there are issues, just let probation know. If you feel like they're not addressing it, you can always come back to court, okay?
Sure.
All right, thank you. All right, this is the last case we're gonna take up before everybody else comes back in the afternoon. John Stephen Meyer. Yes, 1:30.
Thank you.
Hello.
Hi, Your Honor.
Oh, hi. Okay, just 1 second. Your co-counsel sent to the court an email with the motions. And let me just see if I can find them.
And I have copies if you need them, Judge.
Oh, that will make it quicker.
Thank you.
Oh, yeah, if you got it, thank you.
All right, we're gonna go on the record in 2024 CR 0170. The court is in receipt of the defense's notice of appeal with regards to defendant's motion for a new trial. That will be denied.
Your Honor, can I take it that you accept this as presentment of the motion for new trial?
Yes.
Thank you.
All right, then with regards to the defendant's motion for bail pending determination of a motion for new trial and pending appeal, we'll just do it with regards to pending appeal. Defense?
Your Honor, I'd like to make a proffer if I could.
Yes.
The court knows a good deal about Mr. Meyer, of course. So the standard under 44.04 C is he is eligible for bond pending appeal in light of the court's judgment, of course, yesterday.
Yes.
And the two questions are, is there good cause to believe he would not appear? And or that he is likely to commit another crime.
All right, let me just stop you right now. State, do you think that if the court were to give bond to Mr. Meyer, he would fail to appear? And I can tell both parties, the court is inclined to place him on GPS.
I think with full house arrest GPS, I think that would take care of it, Judge.
Okay, so let's start with this. So where we are now is if he has employment,
He's retired, Your Honor. I don't mean to interrupt the court.
All
He's
right.
retired.
so it will be full GPS and counsel. If you wish for him to have a window off of GPS where he can take care of personal affairs or whatever he needs to do, you need to give the court a detailed list of what time he wants and what windows of time. So for now, we know he's going to be on full GPS. All right. So next question has to do with the amount of bond. And counsel, what are you requesting for the amount of bond?
It's my understanding, Judge, and I tried to check earlier and I couldn't today, that he was on a personal bond for this case.
Mhm.
He appeared multiple times. I mean, just between the time he was convicted, of course, and the time of sentencing, he knew he was facing up to 20 years in prison. So I think he's a great candidate for personal bond.
All right. So here's my question. Was he previously on a personal bond?
No, Your Honor, on this cause, it was $40,000, and on the pending cause, it was $50,000. So we'd asked for $200,000, Your Honor.
That's too
Okay.
high, Your Honor.
No, here's the thing. Everyone, just address me. So, Mr. Meyer, I have some questions to ask you about this bond issue. Could you raise your right hand for me?
Yes, Your Honor.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
John Meyer.
All right. So, how much do you receive in your retirement?
I don't really have a retirement. I have a house that I own and rent out in Hawaii, and my wife and I use that to pay our bills.
All right. So, what are your bills? How much?
My mortgage on the house I live in is about $3,200. And I've been paying money out of my retirement. I've been using some of my retirement to
Okay,
pay
so
my
Mr.
bills.
Meyer, I'm sure your attorney will tell you this. Just listen to my questions because I don't want to go into other things.
Yes, Your Honor.
And just answer my question. So you say your mortgage is $3,200 a month. What other bills do you have?
Electric, water.
What's the average cost of that for the utilities?
Probably about 800.
Okay. Other than the mortgage and the utilities, anything else?
No, Your Honor.
Groceries. What's the average per month?
500 maybe.
All right. So and how much do you receive in income?
About 3,500.
Okay. And that's the only income you receive?
I do renovations on houses. I haven't been doing many recently.
Okay. All right. Any other questions?
No questions, John.
All right. So state, are you still asking for $200,000?
Yes, Your Honor.
All right. Defense, what are you requesting for bond? The court is not going to grant him a PR bond.
$50,000.
All right. So this is what the court will do. The court will set your bond at 65,000. There's to be full GPS. I'll ask that the fees be waived. But it's a third-party contract with the county. They're probably going to send me a notation back that fees can't be waived. There is to be regular random UAs and probation. Since probation is sort of held in abeyance till this appeal is pending, are you all able to still do UAs or no? All right. So there's going to be regular random UAs, and that's going to be through pretrial services. And there is to be sober support meetings. And those are to be 2 times per week. And my understanding is they have those sober support meetings by Zoom. All right. And Ms. Ferguson, state, I know that you may feel as though Mr. Meyer may or may not appear, but those concerns seems to be addressed with the GPS, but this is what we will do. Norma, reset this case for 30 days and you'll need to appear in 30 days. If you do not, something else will happen. You understand?
Yes, Your Honor.
Judge, can we do no contact with the same folks from the stipulations?
Who are the no contact persons? Just 1 second. Let me grab the different file. Okay, let me see if I have that file. I don't have the trial file.
Your Honor, we would agree if it makes it any easier that the same people that were named yesterday would have no contact with.
All right, you understand that?
Yes,
So
Your
you're not, you to have no contact with the previous persons that were entered into the motion for probation. You understand?
Yes, Your Honor.
All right.
Your Honor, can I speak to that then? Can I speak to the rest of the court's
Yes.
judgments? We think the amount of bond is fair, but I would think that the full GPS is unnecessary. This man, if that's a concern that he's going to run off, where does that come from?
All right. Now, so here's the thing. What I stated earlier with regards to full GPS. He's retired. That's what I'm being told. If he wants time to handle affairs, or if he decides to get employment, all he needs to do, or you counsel need to do, is to come to court with timeframes for the court. But I'm not just going to give him free reign on GPS.
You know, could we have GPS with a curfew?
Once you all come back to court with a list of what time he would like to be out and about and for what reasons, the court will make a ruling at that time. But for now, it's full GPS. So that's all you have to give me. All right?
We'll be back with that. Thank you, Judge.
All right, thank you. No, that's going to be, he's appealed, so he can't go. Yeah. For ISF. All right, and I'm going to add the no contact orders in here.
Your Honor, I know that sometimes it takes a while to get a monitor.
Oh, it doesn't take that long. They'll have a monitor for him soon.
Could the court allow him to release him today without the monitor, but he gets the monitor as soon as it's available?
No, they'll have those monitors available. If for some reason it's not available, and let's say 3 weeks, although I think they'll have it available by next week, then you just come back to the court and ask Ms. Ferguson to put him on the docket and I'll address it.
We will do that, Your Honor.
All right.
I'm not trying to argue with the court, but he's been a very responsible person, Judge. I know that if you were allow him to release him until he can get a monitor, he'll get it as soon as possible.
Okay. All right. Is there anything else?
No, Your Honor.
All right. Thank you. And I've added the parties in the motion. All right. So we're on recess.
Judge, can I, real quick on my guy, can he come back and would I be excused? Because I have federal court like all afternoon.
No, I mean, yeah, see y'all at 1:30. All right, thank you. Everyone, I'm here, but we're on lunch break.